Good afternoon. Please be seated. We're ready for argument on State versus Hall.
Good afternoon. May it please the court and counsel, Morgan Daniels on behalf of the defendant, Amy Hall. I'm going to focus my argument today on the first assignment of error concerning the violation of my client's right to counsel under Article 1, Section 11 and the Sixth Amendment. The question here is whether the trial court erred when it concluded that my client had waived her right to counsel by misconduct. The answer to that question is yes, the trial court did err. The court assumed that Ms. Hall was engaging in misconduct, but the court had insufficient information at its fingertips, and certainly not in the record, to establish that that misconduct occurred. And furthermore, the court did not give Ms. Hall adequate advance notification that if any misconduct, such as it was, persisted, that she would be faced with the possibility of losing her right to court-appointed counsel in the case and be required to proceed either without counsel or, if she could hire counsel, with privately retained counsel. So under Article 1, Section 11, waiver by misconduct has three prerequisites, and these are set forth in the Supreme Court's case Langley 3. And this court has a number of cases, progeny to that case as well. The first requirement, the defendant must engage in repeated misconduct that defeats counsel's ability to carry out the representation. The second Langley requirement, the court, before sort of dropping the hammer on the defendant, must provide an adequate advance warning to the defendant that their continued conduct may result in them waiving the right to counsel. Finally, the third requirement under Langley is that the court must provide the defendant with a reasonable opportunity to present to the court in a confidential way, if necessary, their reasons why they're doing what they're doing, basically. Here, there's an easy first door out for this court, which is the second factor. There was no advance warning to the defendant here at all about, that her conduct might result in her having to proceed either pro se or having to find her own attorney. The only hearing at which any warning was given to her, and really the only hearing at which the issue was taken up in any detail at all, was the hearing at which the trial court ruled that her purported misconduct resulted in her waiver of counsel. And so that is a hearing that took up, it's at transcript 21 to 28, 7 pages of the transcript. There's discussion of the issue, but the warning comes at one point, and then the ruling comes, probably just a few minutes later. I don't know exactly how long, but that does not meet the requirement of advance warning. The point of advance warning is to give the person enough time to reflect and to possibly change their conduct going forward so that they aren't running the risk that they've been warned about. Turning to the misconduct issue.
Just before you go on.
Yep.
Just so I can make sure I'm understanding your argument. You're saying the simplest door out for us is that whatever warning was given wasn't given with enough time to allow defendant to actually respond to that warning and adjust her conduct?
That's right. All of the cases are talking about advance warning in terms of weeks, days, weeks, sometimes it's even months and years. There are cases in which the defendant's conduct goes on over even a span of several years, and the court warns them at several points, like, hey, if you keep this nonsense up, you're going to end up without an attorney. Here, though, this one hearing was the first hearing at which the issue was even litigated in the court. There was one other hearing at which it was mentioned. Actually, no, let me correct that. There's two hearings. One where the defendant wasn't present, where the court said, I see that we have this motion on the table. We'll talk about it when she's here. The second one where she was present, where the judge said, I see that your second attorney has filed a motion to withdraw, citing, that your relationship is breaking down. We will take that up, and the implication in that second hearing is that there's going to be a third attorney. And the court doesn't say anything about, you're creating this situation for yourself, you're making things hard, you're going to mess it up, and you're going to lose your right to counsel. So she's had no warning until that last hearing that takes place about 7 months after her arraignment in the case, and after she's had 2 attorneys, one of whom withdrew without giving much in the way of detail about the reasons for the withdrawal, and the second of whom was Thompson, the attorney who said, our relationship is breaking down. I want to, since I'm sort of moving into the misconduct area, I want to just correct or clarify what I think is a misunderstanding in the record from the trial court and in the state's brief. At one point, the trial court during this hearing says, he's talking to the defendant, he says, your misconduct has done this and it's done that, and no one wants to work with you, blah, blah, blah. There is nothing in the record that establishes that at all.
That establishes what?
That the reason why my client's first attorney was withdrawing, the trial court says to her, your attorney is withdrawing, you're difficult, nobody wants to work with you, because the attorney had also represented, I contacted the Lane County PD, I contacted the consortium, no attorney is able to take this case, we're asking OPDC to find somebody to take the case.
So when the court says no one wants to work with you because you're so difficult, or words to that effect, you're saying there isn't anything on the record to support that statement by the court?
That's correct. Yes, that's exactly right. What we have in the record are the first attorney's motion that cites a couple of the rules of professional conduct having to do with conflicts and confidentiality, and then a bar opinion about client confidences and how you can reveal them or not to the court if you're seeking to withdraw. And then in that motion, that first attorney also represents, I talked to the Lane County people, I talked to the consortium, there isn't anybody that is able to take this case. There's no detail given about the reason for that. So yes, I am saying there is literally zero information in the record from any source that, aside from the second attorney's motion, that there might be any difficulty in dealing with my client.
So it's not a permissible inference to take the second attorney's experience and impute it into what the first attorney was saying?
No, I don't think so.
And it's not, is it a permissible inference from what the first attorney said in the motion, that it was based on impossibility to work with the client?
No. I think if you look at the motion, and it's at it's supplemental excerpt of record 3, I think, attached to the state's brief, it's a very sort of, not generic, but there's not a lot of information in it, and properly so. That attorney is properly not revealing whatever the underlying, and they don't have to, and indeed shouldn't. So basically, again, the lack of advance notice is grounds for reversal in itself, but we also, my client's conduct here does not constitute misconduct. And we have...
On that point, did the trial court understand this to be a misconduct case, or did it just sort of misunderstand the circumstances in which you could allow, sort of force this choice on a defendant? Because the court ultimately concluded that the basis for having your client proceed pro se was that, it found by operation of her inability to get along with counsel, which doesn't, by its terms, suggest misconduct so much as lack of ability to cooperate with counsel?
Well, I think that given that her waiver was not explicit and that her waiver was implicit, which is usually implicit by misconduct, it's sort of a logical step to get to that. And what the trial court is saying in that is, you're difficult, you're not cooperating, therefore you've waived your right by your misconduct in being difficult and not cooperating. But we know from the cases that not cooperating and not agreeing with your attorney and being difficult may eventually rise to the level of misconduct, but they are not in themselves misconduct. And that's really well explained in Langley and again in Stanton as well. And that's the case here too. So if the court has no other questions, I will save the rest of my time. Thanks.
May it please the court, counsel Patrick Ebbett for the state. Like defendant, may it please the court, counsel Patrick Ebbett for the state. Like defendant, I will focus my attention on the first assignment of error and whether defendant's waiver of counsel was intentional and knowing. For an intentional waiver by misconduct, as defendant points out, 3 requirements must be met. Must be repeated misconduct, an advance warning, and an opportunity to present the client's position with respect to the dispute with counsel. And we submit that all 3 of those prerequisites were met here.
What is the misconduct?
Misconduct is insisting to a highly untenable view of the law and that her attorneys comply with that untenable view.
Well, although as I read it, though, I didn't read her talking about any law except for the fact that she has the right to effective counsel. And so she's citing things that she thinks support that, right?
Right. Well, she cited, I think you have to look at the sort of whole context of what she's saying these things. She's saying repeatedly that she, as a natural person, she's not subject not only to her counsel's authority, but not to the court's authority. She says that from the get-go. She's after she's recording the.
Does her questioning the court's authority have an impact on whether she can work with counsel?
Well, it indicates that she has a highly esoteric view of the law that is frustrating counsel's efforts to represent her. And she makes it abundantly clear that she is not going to accept counsel that does not accept her view of the law. I mean, for example, she says when it comes to Mr. Thompson's motion to withdraw, she says point blank, Mr. Thompson is required to withdraw because he can't provide me effective counsel according to ORS Chapter 244, which is a chapter involving the ethical obligations of government officials. Obviously, the counsel is not a government official.
But her misunderstanding of what the bases for effective counsel, how is that misconduct?
I mean, she's saying, well, it's not simply that. She says the Code of Federal Regulations, the Code of Ethics, there's no attorneys who provide me that are willing to follow the law and the Constitution. You have to provide me effective counsel. I am not subject to the rules that you are. I am a natural-born person. This whole litany of things that's going on in that context, she is saying that counsel needs to abide by her. I mean, I don't think, I mean, I don't see how an attorney can, I mean, as the court effectively said, I'm not going to find you a lawyer.
But we have one lawyer who withdraws appropriately citing ethics rules and does not disclose client confidences. and explains that there is no other available lawyer in 2022, no other available criminal defense lawyer.
Right,
And that motion is granted.
right.
Okay, so we don't, does the state believe that that first motion evidences misconduct on the
I
client's part?
mean, I think there's one, I'm not sure we need to get there because we have the second one. But as an initial matter, yes, I think that obviously a whole record wasn't taken at the time because the court acceded to a request and gave her new counsel. So a whole elaborate record wasn't developed on the reasons for that, for that replacement. But when you look at the record as a whole, you see someone who is refusing to, is being very obstinate, not only with the court. And when counsel's comment that, look, there's no attorney in Lane County, this is not a small county, this is Lane County, Oregon, who is
Available.
I think the inference is that given her behavior toward counsel, counsel cannot find anyone who'd be willing to.
But what about the mere fact that there might just not be another criminal defense lawyer in our state who can represent her in Lane County right now?
I mean, that's one inference. I think another inference is that there's
But
no one who's.
I mean, don't we have to deal with the record we have? And isn't this implicit waiver is taking the place of an explicit waiver, which is,
Right.
we have to know that it's knowing and voluntary. So we're getting to knowing and voluntary maybe by two appellate people dancing on the head of a pin about availability. What does that mean?
Yeah, and I don't think we have to answer.
Okay, so
At
then
at that initial step.
So then we have one lawyer.
We have one
who
lawyer.
gets to withdraw, and then we have a second lawyer.
Right,
Who says there's been a breakdown.
Right.
And my client has asked me to withdraw.
right. And defendant explains why Mr. Thompson was inadequate. She says he refused to comply with, among other things, the Code of Federal Regulations, and that no attorneys you have provided me are willing to follow the law and the Constitution. We know from the
But then we
context of
go,
those statements what her view of the law and the Constitution.
right, but we go straight from that to, well, do you want to represent yourself? There's no questioning about what does that mean?
Well, let's look at her response to that. When the court says, do you want to represent yourself? Her response is as follows. The court says, this is on page 26, you burned through a number of attorneys because of your behavior. And again, it says, look, I'm not going to give you another attorney. You either stick with Mr. Thompson or you represent yourself. This is her response. So what you're saying, yes, sir, what you're trying to do to get me to say, Jay, referring to the court as by his first name, which is consistent with her entire view that she's not subject to
So the
court's
state's
authority.
view is that the defendant's rudeness to the court matters in the analysis of whether she's committing misconduct vis-a-vis her attorney.
I think you can, and I think there's a fair inference from the record that what the court sees here is somebody who has a highly contestable, a highly untenable view of the law, that she is forcing on not only the court, but her counsel. She goes on to say, after referring to the court by his first name, I won't do that. I won't abide by the unlawful administration of justice. You're lucky I even showed up for this. You guys put me through this, not just the court, but her counsel. You find me an attorney and you figure out how to get me out of this. You guys, that's both the court and counsel, are not abiding by her
The court and the
esoteric views.
officers who are arresting her and it seems to me that there needs to be a difference between a generally difficult, a person who is difficult in court with a person who is now found to have waived their right to be represented by counsel. Difficult people are represented by counsel ably across the state every day.
They sure are.
And so the idea that, and the case law so far seems to say that this misconduct is something way up here, right? You're at your fourth or fifth person, you're affirmatively trying to delay or do something with the system. And it all depends on the relationship between counsel and the defendant. I have not read a case, now I could be wrong, where the defendant's behavior towards the court plays into the decision that they are waiving counsel.
I don't think, but I think we're in the realm of inferences of what's happening between counsel and the court, counsel and defendant, based on what she's telling the court about her views.
Isn't that problematic?
I mean,
Isn't that part of that third step in which you need to actually make a record about asking more questions about why? Why is this falling apart? Otherwise, we're left to speculate about a waiver.
Well, I think this case is markedly different than, say, Langley. And I think we all, Langley states point blank that non-cooperation with counsel is simply does not equal waiver by misconduct, because counsel can still go ahead and do their representation even if the client is not cooperating with them. But this is not what defendant is saying here. She's not simply saying, I will not withdraw with the counsel. She's saying, demanding that the court provide her counsel that abides by her untenable view of the law.
And the
and you can infer from that.
Evidence
I'm
for
sorry?
her demanding that the court provide her a counsel that comports with her view of the law is on transcript page 21, when she cites those various OARs and justice policies.
Page 23, page 21 is probably the best example of that. But we have the whole record here of her. You know, she says, no attorneys you have provided me that are willing to follow the law and the Constitution. Shortly after that, she says, I'm a private natural person. I have national unalienable rights. I don't have all these rules to go by that you do. You guys are putting me through this, not me. Again, she's saying, I am not subject to these rules. And I think there's a fair inference from looking at the record of the whole that is her problem with counsel. They are not, she wants an attorney who will represent her. She knows best overall. She said she knows better than the judge. The judge says you have to appear in court. She says, nah, I'm not subject to your authority.
Before you run out of time, I would like to hear you address the problem of timing, because it does appear the judge makes that comment about, I'm not going to appoint you another attorney if you can't work with this one.
Right.
And then pretty soon after that, basically follows through on that. What is the state's view on how that gives her adequate notice as
Certainly
to
the
support a
timing
waiver
is-
of counsel?
Yeah, certainly timing is more compacted than we see usually see in these cases. But I think, again, we look at her response to that. Her response is as clear as day. And I don't see why the court needed to do anything more. In response to that is, Jay, you're trying to get me to abide by the unlawful administration of justice. I'm not going to do that. You're lucky I even showed up for this. Given that response, I'm not sure what more additional reflection would accomplish. She's made it abundantly clear from day one how she sees this proceeding. The court was, let's say hypothetically say something that's more sort of concrete. Let's say the defendant says point blank, my attorney, I want these witnesses bribed. My attorney's refusing to bribe these witnesses. You need to give me an attorney who will bribe witnesses.
Well, that's a pretty distinctly different record than we have.
Yeah, I think that's a much clearer record. But I think we are dealing in here in the realm of sort of fair inferences from the record, and I think we can draw something that's functionally, if not obviously not that strong, but functionally equivalent from a legal point of view, and that is that she is just not going to accept a lawyer that does not accede to her extremely esoteric views with respect to what the controlling authority in this prosecution.
So is your argument that it's adequate notice because the record is so clear?
Yeah, I'm not sure what the court was, what we should expect the court to do as soon as she said, in response, when the court says, in response to its warnings about the risk of self-representation, what do you want to do? She responds as she did, which is like, hey, Jay, you're lucky I'm even here. No, you need to give me a lawyer, I'll do it.
But that, I mean, that may have been, something that would have made her subject to a contempt remedy, sort of her conduct in court was contemptuous and maybe would be grounds for excluding her from the courtroom or having another remedy. But sort of back to the counsel question, the court kind of talked in sort of broad generalities about what was going on and her inability to get along with counsel. What did the court say about the conduct that would have allowed her to know what particular conduct the court thought was misconduct and would have given her an opportunity to stop acting that way?
I mean, the court, I think the court did not say anything beyond, you've got to get along with counsel, and you're not. The court did not articulate specifically, the court, a view that her views of the law were untenable, and until she made those views, until she changed those views, she was never going to have an attorney that would be able to work with her. But I think the inference is, of course, here we have this person who's just being disruptive and rude and saying, you need to give me a lawyer who's going to comply with my esoteric views of the law. The court was entitled to say, this is a pointless exercise at this point. We've been going at this for a few months now. There's no point in assigning her a third attorney and ending up in the exact same place we've ended up with the first two. I see that my time has expired, and unless the court has any additional questions, we would ask that the court affirm. Thank you.
I think that it is likely that the trial judge in this case saw the writing on the wall and could foresee that in the future things might have become more difficult with the defendant in this case. But the correct move for the judge to make at that point was to begin the 3 steps in Langley, not to jump right to the end. And so to say, here's your misconduct, to say, here is advance warning that if you continue with what I see as misconduct, you will suffer a bad consequence, and then say, here's your chance to tell me more about this if you want to. If you want it to be confidential, we'll find a way to have that happen too. But the court did not do any of those things. Really, the lack of notice is enough for reversal here. But I also say that having a strange legal theory does not constitute misconduct. Being rude to a judge is a different order of misconduct, but as you pointed out, Judge Lageson, if the judge wanted to hold her in contempt or warn her that it might hold her in contempt if she continued with her interruptions and referring to him by his first name and so forth, the court could have done that. That's the remedy for disruptive bad behavior in the courtroom. But that behavior, not directly connected to her relationship with counsel. And insofar as the state is arguing that, we can look at it and infer that because she behaved this way in one setting, she was troublesome and terrible in other settings, that's just too speculative. There isn't enough evidence in the record for that.
Do we have any cases that infer an implied waiver?
No. I mean, really, if you look at the actual conduct in cases where this court or the Supreme Court has held that there was waiver by misconduct, actually, I can't think of a Supreme Court case that has held that, but this court's cases, Clardy, Garrett, I mean, the misconduct was severe, as in the defendant is making threats of physical violence to the lawyers. There have been multiple lawyers. It goes on over months. The court warns the defendant at multiple times during the course of, the proceedings that, hey, if you don't shape up, you're going to have to represent yourself. And we just don't have anything even remotely close to that here. And no, it may be that, 6 months down the road, after the court had gone through the proper sort of procedure as outlined in Langley, it may be that the court could have ended up there and could have required my client to represent herself. But at the point that it did so, there was insufficient evidence of misconduct and no advance warning. And it simply erred when it concluded otherwise. She also is capable of working with an attorney who doesn't buy into her theory of the case, just for the record. But unless the court has further questions, that's all I have, and we'd ask you to reverse.
Thank you. Thank you both. The case is submitted, and we will take a brief recess.